Buenas tardes from beautiful Barrio Huanuca in Matagalpa, Nicaragua. It is Sunday, July 27th. I wanted to give you guys an update. This one is going to be veteran-centric. Not my top 10 list, but an update on my own claims. I had a Veterans Board appeal last year that I had a partial win on. The VA agreed with me, and they underfunded the decision, which means I had to take the claim away from the VA and put it in the U.S. District Court of Veterans Appeals in Washington, D.C. That is out of the hands of the VA. It's done through private attorneys. In particular, I used Bergman and Moore. So a personal endorsement, there's no compensation. But I'm going to give you a short story because not a lot of people are familiar with this additional way to appeal something even after it's gone to a VA judge. Before I do that, a little house maintenance. First of all, shout out to Warlord Beard Oil. I did get my last order. I got the hat. This is living proof. Love the hat. I'd gotten Scott Allen Miller one last year in the gray. I got the blue for myself. And it says Warlord Be the Beard. So, no compensation for the endorsement. It is a personal endorsement. I'm not getting any kickbacks for it. Over my shoulder, you will see my tower of cafe. I've got a couple different ways of making coffee over there. I've got a French press. I've got two Chemex, an AeroPress, an electric mocha pot, a grinder, two varieties of beans, and some other Chemex accessories, filters, and what have you, other implements of destruction, because I may be retired, but I take my coffee serious. Okay. Backdrop. Again, this is veteran-centric. If you're not a veteran, you don't have a veteran in your life, or you haven't had to deal with the VA on health care and benefit issues, this will be a little drawn out. You may want to go ahead and fast forward to the later parts. However, I'll give you a quick recap. So, I served in the 90s in the Army, and 6 months into service, I had my right knee buckle on me. I stayed in for over 6 years, and my knees, plural, became a consistent problem the entire time I served. I did manage to get a very small percentage after I got out for my knees and my back. Fast forward, it took from 1999 when I got out until 2016 before the VA finally agreed to scope my knee. If you're familiar, and I'm not medical myself, I have a lot of medical knowledge. I have no certification in medic. But when you have these injuries, illnesses, and you've worked with the VA, and you've had to advocate on your own claims, you learn a lot of medical and legal terminology very quickly. Also, the reminder, I was a veteran service officer with State of Florida, Florida Department of Veterans Affairs for a number of years. I am no longer accredited. This is information that will be deemed valuable, but I cannot give you official answers. I cannot file your claims for you, but I can direct people in the right direction. We have a separate WhatsApp page with our expats that I deal with veteran-centric issues for veterans who are overseas. So this doesn't apply to being an expat or not, but this does apply to veterans. So the right knee has been my biggest source of problems. It was until 2016 when they finally decided to scope it. The joke is it was done on February 29th on Leap Day. Well, the doctor who agreed to do the surgery after 24 years of complaints plus finally agreed to scope it with the understanding we were going to be doing a partial meniscectomy. Once he opened the knee, he decided that it was far greater an issue than we had originally surmised, despite having decades worth of MRIs, x-rays, physical therapy, and what have you. I had gone through every NSAID on the market. The Army believes in giving you toxic doses of Motrin. I was already off of Motrin and on a leave and off of a leave before a leave was on the private market. So ridiculous amounts of NSAIDs, which cause other problems with health. But regardless, so kudos to Dr. Jones. He's no longer with the VA. He did retire. But when I came out of anesthesia from that knee scope, I looked up at the doctor and I said, "So, Doc, how'd it go?" And his eyes turned white and he looked at me and goes, "Oh, I don't know if we'll be able to salvage this joint or not." And I'm looking at him going, "You said what?" He goes, "We went in with the understanding we were going to do a partial meniscectomy." I had to remove all meniscus, We removed the synovium flap, and I had to do a lateral release. The lateral release is actually a much more invasive procedure. You're literally cutting the largest muscle over the kneecap, and you have to wait for it to reattach. So even though this was a scope, and it's about 3 weeks recovery, it took as much recovery for a knee scope as it did for a knee replacement. So I was still working with the state of Florida in a different capacity in 2016 when I got this knee scope done. What happened, I was working with employment of veterans. I was not working as a service officer at that time. I did not know all the rules and the policies and what is a legitimate claim and what isn't and so forth. So I went with the local service officer who worked at the VA clinic to file my claim for the temporary rate increase, because you get a convalescence for a few weeks of putting you at whatever your rate was to a temporary 100% rating while you're convalesced, and then drop you into a new reevaluated condition post your surgery, pending on how much range of motion, pain, disfigurement you have from the process. So unfortunately, the service officer who did my claim was pretty much retired on active duty. He was coasting along, collecting his check, doing the least amount of work. And in 2016, the VA claims process was still very cumbersome, and it was very low-tech, unlike the last few years where they've taken some dramatic strides. Now, everybody has a different experience with the VA. I know there are horror stories, and there are good stories. This is my personal experience with professional knowledge included. This isn't a rah-rah-rah for the VA, and it's not a hit piece either. So things went right, things went wrong. In the service, we would have had an after-action review, and I would have had a couple pages worth of this information to say what went right, what went wrong, and what they can do to do things better. The surgery in and of itself was a success. I was rehabbed in about 3 weeks. Now, when you do that, you end up having to have another claims and pension examination done. The claims and compensation exam I had was done by the C&P examiner at that VA facility, who unfortunately does her job with prejudice. I know this because of, one, the way I was treated as a veteran patient, and two, 3 years later, I'm actually working at that facility at a veteran service position, and I'm reviewing hundreds of exams done by this doctor and the other doctor, who both said, and I quote, "Veterans aren't here for health care, they're just here for money." First off, you shouldn't be in a medical position if you have that prejudice against the patients you're seeing. And two, you sure as hell should not be evaluating veteran claims if you assume everybody is overreacting, lying, and exaggerating just to get money. These are people who have service-connected disabilities, many of which have been from war. If you kind of remember, we were at 20-plus continuous years of foreign occupation with new levels of illnesses, injuries that we had never seen in U.S. history in the past. So either way, I did not realize that this doctor was going to under-evaluate my knee, and two, I wasn't in the job yet to know better of what my options were. When I asked the service officer what I could do, he says, you just list for the knee condition and hope for the best, versus the reality is the knee is a joint which can have 3 separate simultaneous evaluations. More often than not, if you have a knee disability, you are looking at a loss of range of motion with inflammation, and you're looking at pretty much a 10% rating. Now, the second claim that can be done on a knee, simultaneous to the first one, because my original rating was for retropatellar pain syndrome, RPPS, runner's knee, very common diagnosis just to get you away and not deal with the issue. Here's Motrin, here's a sports wrap, do physical therapy, do lots of walking, spend time in the pool, look both ways before you cross the street, don't step on a crack, break your mother's back, all that garbage. So the second one you could have a listing for is a loss of range of motion is the first. The second is having an instability. So if you have instability in the knee, such as it buckles, gives way, that is a second claim that can be involved. The VA should be looking at the full range of motion for either extension or flexation, and they measure it on a scale, what looks like a protractor, and they can evaluate in that situation. So long as you demonstrate a painful range of motion, you're pretty much looking at the guaranteed rate of 10% disability on the knee. If you can document instability of the knee, buckling, falling, then that is a second claim. Well, with the surgery I did, there is a third claim, the least often used claim, and it's called removal of synovial material, the synovium flap. So again, without being a doctor, you basically have a sheath over the front of your kneecap that has, basically it's a pad, which can be inflamed, which can be torn, much like the meniscus, which are very small muscle, well, they're tendon materials. But that is a third claim, removal of synovial material. Now, again, didn't know this in 16 because I wasn't in the job, but found out later on, once I was in the job, that you could have the 3 simultaneous independent ratings on your knee. And if they are truly warranted, it's the VA's responsibility to include the C&P examiner to maximize the veteran's claim, not minimize the veteran's claim. So I already had the 10% for the painful range of motion. I was still having problems with my knee giving out, and I was a cyclist at the time. Running was done by 99. I went back to bicycling. I did a lot of mountain biking in Florida. I know it's flat. I hear it all the time. I would stand the ground. I'd show you places that aren't flat in Florida that you may have a difficult time getting up and down small hills on a mountain bike in the woods, in the swamps, in the glades. So I should have had a rating for instability. And the third was, after the surgery, and it's fully documented, you removed the meniscus, you removed the synovium. That should have been a third claim. Now, normally that painful range of motion, you're looking at a 10%. If you have a severe restriction in the range of motion, you might see the 20. It's very difficult to see the max of 30% for that first conditional rating. Instability is rated at 10 to 30%, depending on how severe the instability is. If you're awarded instability, it tends to be at the low ball of 10%. Removal of synovial material, 10% rating. So potentially, I should have had 3 separate, independent, 10% ratings on the right knee after the first scope on February 29th of 2016, and I was 3 weeks rehab, so it would actually go into March. The doctor did not maximize the claim, and in fact, she played games. Now, I only had a rate increase for the right knee. She did an exam on the left knee, which has got a 10% independent rating for painful range of motion, and she downgraded my left knee. Another little rule people don't know about, I already had the left knee rated at that 10% for over 5 years. There was no evidence of improvement. It had been bad since 95, and here it was 2016. So as she gave me an increase on the right knee, she decreased the left knee, something that she's not supposed to be evaluating, again, because all veterans are liars. Still wasn't in the job, didn't know better. We're going to fast forward. I tried to do an appeal on this, and that's when she played the numbers, and my rating basically stayed the same post-knee surgery. Now, if you know anything, and this is an unofficial response, but many orthopedics will tell you, after we cut you open the first time and do any kind of scope, particularly on the knees, because they're the biggest load-bearing joints in the body, you've pretty much accelerated the timetable to the inevitable knee replacement or worse. So February 29th of 2016, I get my scope on the left knee and a full meniscectomy removal because I had full tri-compartmentalized problems. They gutted everything out of the knee. And even my own orthopedic doctor, well, again, through all the diagnostics, through all the years of people saying, oh, it's not that bad, it's not that bad, once they opened it up, regardless of what the MRI showed, he saw severe trauma in that knee. So it's not 3 years until I wound up having the knee replaced. So This is how that went. I took the job at the beginning or end of 18 with the state, transferring from Department of Economic Opportunity, which was a horrible job under the guise that you're helping fellow veterans find employment, teaching them employment skills. Personal opinion, it was a total scam. The Department of Economic Opportunity is a way for Florida Enterprise to siphon federal funds away from veteran services and put them into corporate welfare for a handful of companies that do business, backdoor business, with select individuals at the higher levels of Tallahassee. I testified against my own employer with the Department of Labor under a federal audit, showing millions of dollars being siphoned away in statutorily restricted funds that were there to help veterans. And that money was going into the pockets of a pseudo-private CEO driving a brand new Tesla back in the day. So I left there. I found a much better job, much more rewarding job, a job that truly benefits fellow veterans as a veteran service officer with the state of Florida. So the VSOs at the state level tend to be embedded inside VA healthcare facilities. It makes it convenient for the veteran. Hey, I got to go see the doctor. I need to drop off paperwork for my claim. I need to go see a claims officer, create a claim, submit supporting documentation for a claim, ask questions, what have you. So I got that job, and who was training me but the guy who shuffled my paperwork, who was retired on active duty. He was still under the impression that I was far too slow doing my job because he was used to seeing over 18 to 22 people a day and shuttle them through the door as quickly as possible so he could go home and drink. I had an HR background in the Army. I had an HR background from county and state level, and I have my own injuries and wanted to learn as much as I could. It turned out a job that I was scared to take because it was so knowledge intensive and so responsible. Found out I was actually really good at, and I put myself in the shoes of every veteran sitting in front of me, and I wanted to maximize their time because it took so long to be seen by a service officer. At that time, veterans were waiting weeks to be seen. It's worse than that now. I learned the job. I learned the job very well, and now I'm working in the same building. Now, as a state service officer working at the VA facility where I get treated, I am not supposed to do claims and pension exams in the building. I'm supposed to be sent outside so there's no conflict of interest. The state and the VA both railroaded me into doing continual C&P exams at the VA with these same doctors who are actually nurse practitioners. I don't discount the abilities of a nurse practitioner. My primary care provider at the VA is an advanced nurse practitioner, and she trains doctors at that VA facility. Nurse Miller is an absolute rock star. She's been great for years. I fired 3 VA doctors in my time. I landed on her doorstep about 5 years ago, almost 6 years ago, and she's been nothing but great. So kudos to Tanya Miller. Keep doing great jobs. Keep doing what you do. And her staff as well. So I was ramrodded into going into additional exams with a medical professional who has a prejudice against the patient she sees. Now I have knowledge under my belt, and I try to articulate good questions, and I continually get responses that all veterans are liars and we're just there for the money. Now I have enough information to know that this person should not truly be in the job. I went to the local VA, I went to the regional supervisors, I went through the state, through Florida Department of Veterans Affairs, I talked to my county commissioners, I talked to my state representatives, I talked to the federal representatives, I sent letters to the governor of Florida. I could not get these women removed from their jobs who were causing greater ill than good and causing detriment to veterans and additional stress. They're being told they're liars and they're faking it. These are people with service-connected disabilities from combat or other, and they're being told they're liars. If you know anything about veterans, when you question our integrity or call us a liar, we get a little ignorant and bad things could happen. Heaven forbid the veteran has post-traumatic stress disorder and you just triggered them by calling them a liar about their illnesses or injuries. Hopefully they don't have the VA police involved in the situation. But either way, I could not get these people removed from their jobs. Fast forward to 2019, December 30th of 2019, I finally got the right knee replacement because I'd gone, Dr. Allen had already retired. I had a new doctor, Dr. Beavis, who again was a rock star, understood the situation, but was very reluctant to do any additional surgery because I'd already had everything removed out of the knee they could. And I had to quit riding my bicycle, which I truly loved. I loved mountain biking. I'd been on a bicycle since I was a child and loved it. I was even doing it semi-competitively with some friends. I was doing it for charity, doing the American Diabetes Association Tour de Cure. I donated my last two-wheel bicycle for charity. It had over 10,000 miles on a Hard Rock Pro Specialized mountain bike. So I'm very distraught. I can't even ride my bicycle anymore. I'm in constant pain. My knee is buckling daily. I'm hitting the ground on a regular basis. I was very lucky the doctor understood what I was telling him, and I'm also even luckier he didn't go the full weight, but I literally had to tell the doctor, if you don't do something about this leg, I'm cutting it off. That's how distraught I was. It took 27 years of complaints for the VA to fix this knee. It buckled on me on May 10th of 1993, got it scoped for the first time in 2016, finally got it replaced in 2019, which was the greatest option I had. I can't kneel. I can't ride a bicycle anymore. I don't run. I wasn't a runner to begin with. Stairs are difficult. Hills are difficult. Long hikes are difficult. A lot of things I just cannot do anymore. However, the knee replacement was still the best option for me at that point. So if you know anything about knee replacements, historically, you were put on temporary 100% for 13 months and then evaluated. After you've had a knee replacement, all the loss of range of motion, removal of synovial fluid, instability, all those, whatever ratings you had prior, get put off to the side, and most of the time they are replaced with a minimum of 30%, maximum of 60% for a total knee replacement. In some situations, you may still have an instability rating. You can't have the removal of cartilage claim anymore because there's no knee left to have cartilage. You now have an artificial joint. So the loss of range of motion is normally covered with that 30 to 60% for the knee replacement, but technically you could still have instability. More often than not, the VA used to just do one total evaluation for the knee. A good knee replacement, a positive replacement, is a 30%. If you had a bad reaction or a bad surgery, you may be rated very well at 60%. And if you're rated at 60% on the knee, it could mean, again, not a doctor, it could mean that you're looking at another revision, which means them cutting open, taking out the replacement, putting a new one in, and doing all that rehab all over again. Now, when you're done with this, you tend to have a nice long scar on your knee. They have to recut that same scar, go back in. Every time you go back in, you are losing tissue connectivity. You have a greater chance of a buildup on the scar and a greater loss of range of motion in the knee. Knock on wood, that has not been the case yet. So, I get my rating for the 100% for a year, and the left knee was failing me because I'd overcompensated with it all this time while the right knee had been failing me. So it was already in my mind that I was going to be doing the left knee approximately a year to 2 years after the right knee, which is exactly what happened. Both of these, I had waited decades for a solution. I was adamant I was going to have the most positive rehab I could. I was driving with right leg on the gas 21 days after surgery. Now, after I got off of the convalescence from the house and I was done with the walker and I've got crutches, every time I got done with a client at the VA doing benefits claims, I did a lap of the first floor. So I was doing about a 250-yard brisk walk with the crutches about 12 times a day. Now, mind you, I've had a I've had a really great work ethic to a fault, and I've overworked. That's one of those symptoms of PTSD. And I threw myself into my job, ignoring my own health. So by the time I got back from the rehab, and I'm now seeing customers with crutches, and I'm trying to help people, I'm already working 50 to 60 hours a week. By the time I left the job, I had been working over 70 hours a week. Never got the overtime. The state of Florida doesn't believe in overtime. They believe in comp time. And the catch-22 of that is, if you had the time to take comp time away from the ever-building workflow that you have, you wouldn't have worked over to begin with. I was owed thousands of hours of unpaid compensation when I left, and there was not an attorney in the state of Florida, even if they claimed to do employment law, because employment law doesn't have big payouts anymore. They don't have the time. It's not worth their time to do it. And second, nobody was going to take a claim against the state of Florida with Ronnie D at the helm. So I left away somewhat bitter. I did get a small pension from the state of Florida. I have 13 years with state of Florida, and I get a $350 a month pension for 13 years of my life with thousands of hours of unpaid overtime. Whatever. I'm retired. Everything I've ever done in my life has brought me to this moment, and now I can share that information with others. I may be an example in some situations, but I'm also a warning. So don't do everything I've done, but take the best and forget the rest of it. So I come off of the rehab, and I automatically get the 30% for the right knee. I had the left knee done. I automatically had the 30% for the left knee. I've still got a back rating. And then, as I learned my job of what else was rateable, I finally filed for my tinnitus, which is normally the very first thing we would file for you. As a service officer, the easiest way to get a veteran access to VA health care, if they had not already acquired health care or applied for it or was eligible for it, was to win a service-connectable disability rating. Tinnitus is the #1 condition for all veterans, all eras, all ranks, all branches, because the military is a loud place. The constant ringing in the ears, we pronounce it tinnitus, others pronounce it tinnitus. I say tinnitus. I was raised in the South. So I get the tinnitus claim, I've got a back claim, I've got 2 on the knees. Now, in the meantime, even though these were successful surgeries, I started having nerve problems. I had peripheral neuropathy in both legs. I also had drop foot going on. And again, this isn't any disdain against the surgeries I had. The surgeries themselves were relatively successful, but I had also been dealing with these conditions for a number of years, over 20 years. We then start finding out about toxic exposure. Now, this is before PACT Act got signed. So I'm going to refer to 2019, especially with the Appeals Modernization Act coming out. A lot of great things happened at the veteran benefits level. We had hired more people. They had streamlined the appeals process. So if you've talked to veterans, particularly the Vietnam-era veterans, that had to go through and see a VA judge, you used to wait years to see a VA judge. You're going to wait longer now. You have 3 options when you disagree with a VA claim and you can't submit additional information, you can't find an error of fact or an error of law in the original ruling, and ultimately it's going to take a Veteran Benefits Administration's administrative judge to resolve it. There's 3 lanes that you go down. Either one is a direct file review. Hey, judge, all in. Here's my whole claim. I'm not going to add any more information. The errors in this claim should be self-evident. You don't need any more information from me. You don't need to talk to me. That's your quickest path. And historically, it was a year turnaround for that. Now, that's kind of a gamble, because if the VA didn't understand the problems they had to begin with your claim, now you're hoping and putting faith in a judge who you're never going to speak with to do the right thing. The second one was, hi, judge, here's my claim. I want to give you information at some point in time in the future before we speak. Those take longer. Now, if the error is so egregious that it's already documented, I don't have additional documentation to submit. I never understood why you would want to do that one unless you're waiting for key evidence. If you're waiting for key evidence, that means the VA didn't have the key evidence, which means that they were half justified in what they did to begin with. The third option, the longest option, I want to see a VA judge. I don't want somebody hiding behind a decision in an invisible office. I want to see a judge one-on-one. Now, in the modern world, you do that over the screen. You don't actually physically go to see the judge. Waiting to see a judge, because there's only so many judges to see all the veterans who have an appeal, is very time-consuming. So I put in an appeal because I found out doing the job that there was a clear and unmistakable error, that the VA had not maximized my claim. They never gave me the 10% for the removal of synovial material prior to the knee replacement. They never rated me for the instability prior to the knee replacement, and I still had instability after the knee replacement. So I put in an appeal in 2019. I want to see a judge because I don't trust the BS that's happened to this part, because at this point I'm in the system and I see how these claims are working out and how the appeals are working out. No. I want to articulate in the VA's own language to a semi-intelligent human being that's called a VA administrative law judge, and I want to explain to them the errors that the VA has consistently made over the years. I waited 5 years for that video teleconference. It just happened last year in 2024. 5 years to be on camera with the VA judge. In fact, it was in July of 2024, so it's been a year. It took them about a month to come up with a decision that they agreed with me. They should have given me, I got to file that in August of 19. And they agreed with me. There should have been a rating for the removal of synovial fluid material, and that they should have rated for the instability. What they failed, they only rated the claim from the time it was filed in August of 19 until the replacement in December of 19. Now, normally, in most situations, your claim is only effective from the day you filed it. What I filed is a situation called a clear and unmistakable error. The claim, the error made is so egregious and so in your face that the VA needs to go back to the day the error was made, not the day you filed the claim. I had tried to do this through the other service officer, not knowing the VA was supposed to maximize the claim, not knowing that he didn't do the job, not knowing that the evaluator was doing this job with prejudice, didn't know. I wasn't in the service position at the time. Knowledge is power. So now I file this clear and unmistakable claim, which are not easy to win. But quite simply, the surgery was February 29th, 2016, and you did not provide the 10% rating for the removal of synovial material. That's just an uncontestable fact. For over 3 years, the knee had been underrated. I finally get to see the judge July of 24, and in August of 24, they agree with me, and they paid me for 3 months of retroactive adjustment, not 47 months of retroactive adjustments. They totally did not review the testimony with the judge. The VA cut and paste answers about what's mild, what's medium, and what's severe from Webster's dictionary, and then didn't review my testimony and didn't even consistently respond back with their own evaluations, but acknowledged that they had made errors. So I wound up getting a $2,000 check, not a $10,000 check. This was from a VBA decision, waiting 5 years after the claim had gone for almost a year. So when you lose or disagree with the VBA judge's decision, if you do not have new evidence that wasn't reviewed before, you pretty much are looking at taking the claim out of the hands of the VA, putting it in the hands of U.S. Court of Veterans Appeals in Washington, D.C., where a private attorney is going to handle it. There is a $50 filing fee. The $50 fee can be waived if you are broke. So at the time of filing this, I was still waiting for my SSDI to be approved. I was not working. I only had my VA disability coming in. I hadn't received my VA, my state pension, didn't have the Social Security yet. And the bills are mounting because you can't work while waiting for Social Security to come through. It's pretty much designed to put you into debt for the 1 year wait. And just FYI, when you go get evaluated by a doctor for your Social Security disability, much like the VA C&P examiners I had, those doctors that are evaluating you for a federal benefit are actually hired at the state level, and they are pretty much paid to deny downgrade. So that's why you hear the vast majority of people being denied the initial round. Then you have to appeal it, and you have to wait longer. Even though the doctor that evaluated me for the SSDI said, and I quote, "You would have been a great physician's assistant." So obviously I knew what I was talking about. And when I tried to get off the table, my knee buckled on me after having both knees replaced. So again, paid to deny your claim, which is what a lot of veterans claim the VA does, is deny, hope you die. I will never say that the entire organization is out to get you, but I have firsthand knowledge. There are individuals in the VA who take it upon themselves to be the personal gatekeeper to the finances of the VA, and that's not their job. The VA gets its funding by inclusion of new veterans, not turning veterans away. The VA gets more funding by adding to a VA disability rating to justify their funding. It is totally against the grain to deny claims and ask for more money for a bigger budget. So there's where I will disagree with many, but I understand the perception because, again, it's horrible when you have a doctor working against you that's supposed to be working with you. So I send this to U.S. District Court of Appeals. The private law firm that's handling this is Bergman and Moore. Shout out to Bergman and Moore. They have done great things for me. If you're not familiar with the name, they are pretty much the largest private law firm that is veteran appeals centric. So large that they actually provide training materials for the VA administration that works on their side of the claims, and they provide training for service officers at state levels. They provide training for the fraternal orders that still have service officers, like the American Legion, the DAV, and such. So, highly reputable organization. In fact, they told me the appeal decision from the board before I got the hard copy in the mail. Very proactive. Shuffling the paperwork, signing electronic documents, sending things off. There is a process like anything else. This process will normally take about a year's time on average. And the summary of this is, once they get the paperwork together, it's you versus the VA, which is basically the law firm versus the VA. They have to request a copy of your total military medical record, your military personnel file, which the VA already has, and a copy of the full claims packet, and there has to be a full review. And what you're waiting for is the day that there is a very informal discussion between the VA and your law firm, and they may see a clear resolution right then and there. If they do, they can say, you know what, this doesn't even need to go in front of a judge. We're going to kick this back to the VA so they can fix their mistakes. That is a remand. So a partial remand would be, yes, we agree with the decision, but we disagree on the compensation or the severity, which is my situation. Because I agreed with the VA rating me for the removal of the cartilage, and I agree with the VA rating the instability, I disagreed on the effective date of the claim because they forgot their own definition of a clear and unmistakable error. Should have gone back to when the error was created in 2016, over 3.5 years before the claim was filed, and almost 4 years before the knee was replaced. Fast forward more, back and forth. I just got 2 days ago the notification that the VA has agreed with my attorneys on a partial remand back to the VA on these situations. So what happens now is the VA and the attorneys have both agreed on where the mistakes were made, how the mistakes were made, and then they send instructions back to the Veteran Board Administration, Benefits Administration, on what they're supposed to do to either continue arguing, which is near futile, or how to correct it. So, for all intensive purposes, at U.S. District Court of Appeals, I've won a partial remand because we both agree on the disabilities, we disagreed on the severity and effective date, and the instructions in front of me now goes to the VA. They now have to fix their administrative errors and make a new award. Even with this win, this could take months up to an additional year, but I'm winning. What started in 2016 will probably be completed by 2026. The knee replacement in 19, the claim in 19 will probably be completed 6 years later. Things are slowing down in the VA system. So here's an understanding of why things have slowed down. You had the Appeals Modernization Act, which has a big learning curve for both the VA and service officers and veterans. When you do that, you potentially have a lot more approvals, but you also have a lot more claims being filed, which actually creates more traffic jam in the pipeline. If doctors are not fully versed on how to do their job accurately, that do the evaluations, you're going to add a bigger logjam in the pipeline. Now, that happening, while we had the PACT Act being approved, the PACT Act, which happened a few years ago, was one of the largest expansions of benefits and healthcare access for veterans, primarily a lot about toxic exposures. While this happened, you also had a whole bunch of new claims being approved, conditions that were service connectable, presumptive conditions, a new process to file for things that had high probability but weren't listed as presumptive conditions, like toxic exposure, particulate matter exposure, burn pit exposures, a formality to the Camp Lejeune claims. And while all that's happening, you have an attrition of people leaving the workforce, not just because of the job, because of the age of people. You have a lot of boomers retiring. The next generation, the smallest generation, is Gen X. We had least amount of us in there, and you have a new influx of veterans coming into these jobs who are from the Middle East era of 20 years plus of occupation, with a whole new level of disabilities. And in the process of all this, there is a total disconnect in the VA benefits processing. So you've lost a lot of the seasoned people who did the job. Now, in some situations, it's good because some of them were retired on active duty and were just there to collect a check and rubber stamp claims just to get people through. But you lost a lot of the knowledge base on how to do the claims. It took me a very long time to learn a lot of the medical and legal terminologies and what you could and couldn't do, but I learned quickly, and I helped tens of thousands of fellow veterans with their claims, as well as helping myself. So I'm very proud of the work I did. I still offer advice. Again, I'm no longer credentialed. I cannot give you the official. I will tell you supporting documentations. I'll tell you policy and procedures, and I'll tell you who to get the claim through the quickest, but I can't actually file the claims any longer, which is good. I needed to do the disconnect from the job, and retirement's great. But I want to let people know, you can still contest these. A VA decision that you waited years for that isn't right, if you know it's not right, your service officer knows it right, if it's obvious the VA screwed up yet again, you still have the option to go through the District Court of Appeals. And if your claim has warrant, the odds are in your favor in time. You may very well win your claim. Now, that being said, I have 2 more claims that are in the VA's benefits appeal system waiting for the judge. After that first claim of waiting 5 years to see a judge who still couldn't get the claim right, I don't recommend to anybody waiting to see the judge, because you're not going to be given the best opportunity. My advice to all veterans, if you have to put something in front of the Veteran Board of Appeals, send it direct file review. Why? Because right now I have no confidence. I have a vote of no confidence in the VBA processing when it winds up in front of a board. Do the 1 year wait for the judge And if the judge still screws the pooch on your claim, you can now take it away from the VA, put it in the hands of a private law firm who has no agenda to deny you. They work for you. They legitimately are a private interest working for you, unlike the VA, who as an organization is designed to help you, but has individuals in it that undermine that ability, or are undertrained, or have their own private agenda and shouldn't be in their jobs at all. So I have an additional claim right now for housebound status. While I was waiting for all these things to happen, my PTSD went through the roof. I pretty much became a hermit for over a year and a half while I was waiting for SSDI. Traffic situations in my area became horrendous. I had several instances with road rage, either my own or other people pulling off to the side of the road and starting to pound down my car and trying to get into fights with me. And in the meantime, I knew I wanted to move, and I don't want to wind up in jail, and I don't want to be a statistic. Because if you look at me, I'm exactly who you're going to see on the 5 o'clock news. Single white male, above average education, PTSD. Oh, and then this happened. In a court of public opinion, I'm automatically guilty, and I'm just another one of those guys. I refuse to be written off as a number or a stereotype. I stayed home. The only time I left home for a year and a half was for medical appointments at the VA and 2 meals a day. Because of the rheumatoid I have, I couldn't cook for myself anymore. I started dropping plates, pans, and it's embarrassing and it's humbling, and I'm here to talk about it today. I barely cook for myself right now. I'm still out eating twice a day. Difference is, here in Nicaragua, I'm supporting the local economy with 2 meals a day out of the apartment, and I'm pretty much here the rest of the time, other than my 1-hour class of Spanish every day. But I've dropped food here trying to cook. I'll be doing gallo pinto, and you have beans soaking overnight. You cook them for a few hours, and you cook your rice, and you got to put things together, and boom, that's all over the floor. It pisses me off. There's not a lot I can do about it. So the housebound status got denied because the VA said, well, you don't have a 100% rating with an additional 60% rating. I have a combined 100% permanent and total rating. My PTSD was rated at 70%. And the reason it was not rated at 100% is because I hadn't been locked up, incarcerated, or put on a Baker Act. Because I was smart enough to restrain myself. So the penalty for being smart enough not to go to jail or not to be locked up for psychological evaluation was, oh, you're not that bad. There's a second criteria the VA can warrant your housebound for, and that is severe confinement to your home. The severe confinement to my home was I didn't want to get locked up. I didn't want to get in a fight. I didn't want to argue with people. I used to go walk a bridge in my hometown at 4 o'clock in the morning. So one, I could get exercise, because walking and yoga are the only two things I have left to do with bad knees, rheumatoid arthritis, cervical radiculopathy, peripheral neuropathy, drop foot, and everything else going on. And even at 4 o'clock in the morning, I was getting into altercations with people. I was not doing well with people. I was not in a good place in my mind. And I did not have local support. I had a lack of support from my immediate circle. Immediate friends and family didn't have an understanding of how to respond to me. And I tended to rage out. Nobody actually got hurt, but I was not in a good place. So I filed for my housebound. So under the severe confinement to housing, totally separate criteria, the VA said, oh, well, you didn't have a severe confinement and 100% for PTSD with an additional 60% claim. And that's not how their regulations read. I put that in under direct file review. Direct file review, it got to the judge in 10 months. When you do direct file review, the claims are supposed to be resolved by the judge in an average of 4 to 8 weeks. I am over 4 months of my claim being sitting on a VA judge's desk, and I'm pretty much certain that when I get the response someday from the VA, the judge who's been sitting on my paperwork for many, many months is going to regurgitate the last answer from the VA without reading my statements, without reading the situation, without reviewing the mental health counselor's information, and is going to continue the denial. So I've already told Bergman and Moore I have an eminent claim to go in your hands, and I expect that one to take about a year's time from the time they receive it. And I spoke to the rep yesterday on the phone. She kind of giggles. She's like, well, at least you understand, you've managed your own expectations. I said, yeah, I have a vote of no confidence for the VA's benefit system right now. They're overburdened. They don't have quality people in. There is an overflow of veterans. There's not enough service officers to assist veterans on either side of the glass. It's kind of a big cluster. And the third claim, toxic exposure. I was at Fort Lewis, Washington from 93 through 96, and then to Schofield Barracks, Hawaii until 99, with 6 months for good behavior down in Guantanamo Bay. Fort Lewis, Washington, like almost every other U.S. military base globally, failed the EPA water inspections 6 years ago. And it's been known for decades. Fort Lewis, Washington had illegal dumping by the government near its watershed and near its deep wells of trichloroethylene, which is a metal degreaser, lead, arsenic, and a whole bunch of the PCB, PCAs, PSCBs, MOUSEs, all the forever plastic, forever chemicals. But trichloroethylene is kind of a big deal. Why? Because trichloroethylene is already listed as one of the primary contaminants in Camp Lejeune, where we have presumptive conditions for Camp Lejeune water exposure because they had dry cleaner solvents being dumped into their water reserve for decades. And they knew it, and the government ignored it. And the government has a pattern of ignoring their own toxic exposure because they literally wait for all the guilty parties to be long gone dead so nobody can be penalized and nobody's held accountable. The dumping at Lewis happened from the 30s through the 70s, and it was being addressed in the 60s, and it was kept quiet for almost 35 years. There were some exams being done, but quite simply, for almost 3.5 years of my life, we bathed in, drank, and consumed metal degreaser. Some of the biggest problems with these volatile organic compounds is they will cause initially inhalation problems. So I've already got my sinusitis rhinitis service-connected from my time at Fort Lewis. When I got to Lewis, I had chronic bronchitis. I had chronic sinusitis. Now, I was a smoker at the time. However, smoking doesn't eliminate your claim. Just because you were a smoker once doesn't mean that that's the only causation for these conditions. I've already been service-connected for the initial problem. Second, I had what we thought to be, never confirmed, chronic kidney stones while at Fort Lewis. One of the biggest problems with trichloroethylene exposure is kidney disease, chronic kidney disease, which winds up having to be kidney cancer for it to automatically be service-connected. But we do not have presumptive conditions right now at Fort Lewis, but you do have presumptive conditions at Camp Lejeune, where basically the squeaky wheel got the lube. Bad pun for the lube job with the metal degreasers, but that's what it's been. There was enough noise for 35 years of contaminant at Lejeune, because it's one of the major training bases for the Marine Corps, that it was hard to ignore. And also it's kind of hard to ignore a very loud Marine when they're pissed off because they're dying of cancers. So I was never diagnosed with a kidney cancer. I had chronic kidney disorder while at Lewis. The kidney issue went away when I got away from the military. Imagine that. So I have had other health conditions that I no longer have that could have been attributed to the contaminants, but I have no residuals for those, so they're no longer claims. But what I have claimed is my rheumatoid arthritis being service-connected to the metal degreasers, because there is a high level of evidence of immune disorders. If you know anything about rheumatoid arthritis, rheumatoid is an immune disorder, so much so that I was taking methotrexate, which can kill you, and I'm off of it because it was causing adverse reactions. I'm still taking hydroxyquinine, which is Plaquenil, which is a much safer option, but is still dangerous to use. And I now have to take weekly shots of a biosimilar to Humira. which is also a black box listing. These medications suppress your immune system so much that it puts your life at risk. It's deemed to be a greater benefit than harm, but I have 2 black box medications for the rheumatoid. Now, I've applied for the rheumatoid under immune disorder. It's been denied continuously. At first, they denied it because they said I didn't have rheumatoid, which was confirmed, and the VA corrected that. So they have agreed that I was exposed to toxins while in Fort Lewis, and they have agreed that I have rheumatoid arthritis, but they won't complete the nexus of the 2 because there is no official listing for presumptives under PACT Act unless you were in the desert with burn pits or the confirmation of the Camp Lejeune claims. So even though I'm exposed to the same chemicals that Camp Lejeune was exposed to, there is not a presumptive list for Fort Lewis specific, and we're not even talking about the toxic water at Schofield Barracks in the 90s. If you went up to the water reserve for Waiwa, you looked down and you saw, because of all the runoff from Dole plantations, the freshwater reserve looked like radiator fluid. I'm from Florida. I know what agricultural runoff does to water. All you have to do is look at Lake Okeechobee, look at the algae blooms in the Gulf and the rivers in Florida, and see what industrial runoff has done to the ecosystem. In Hawaii, they don't have rivers. There's very few wells. You're on a pimple in the middle of the Pacific. They rely on collecting rainwater. And the water used for agricultural there made the water unsafe to use. So much so that there was a danger sign at the freshwater reserve that said, don't touch it. And again, it looked like neon green radiator fluid. So Schofield had trichloroethylene. I have 6.5 years of exposure. We're not even talking the 6 months of living on an airfield in Guantanamo. So now you want to talk about aqueous foam and the PFOCs and PFOS and PFOAs. I worked and lived on an airfield for 6 months while in Guantanamo Bay. Didn't even go into that realm. But ultimately, the VA has denied my immune disorder being service-connected, in part also because my mother had rheumatoid. Now, they wouldn't know that unless I had told them, which I did, because both my mother and I, neither one had a genetic marker for the rheumatoid. The genetic marker is a pretty good indicator on whether or not it's genetic or not, hence the term genetic marker. My mother did not have it, I do not have it, and my rheumatoid developed in about the last 8 years. So I am still waiting until approximately November for the direct file review on that, for the VA to regurgitate the same answers they've already given about toxic exposure. And I'm going to turn that one over to Bergman and Moore with an understanding that I'm probably looking at an additional year plus. Now, when I spoke to Bergman and Moore, they do have extensive experience in doing toxic exposures, not just PACT Act. But I don't expect the attorneys and the VA to come to the informal resolution early. I do expect that one to have to go in front of either a district court of appeals judge or a panel of judges. That, in my mind, means I'm adding another year. Now, I'm already at 100% permanent and total. There is no need for a higher rating to get VA health care. I have full access to VA health care. When in the States, all my health care is paid for. As a veteran living overseas, I'm eligible to use the foreign medical program. And if you watched my first veteran-centric video on here about it, the foreign medical program is a crock. Even if you're 100% permanent and total, it will only cover your service-connectable disabilities. So 100% P&T, unless you had an injury to the mouth, there is no dental being covered while you're overseas. You're paying for that out of pocket. 2, the VA will not ship any medications overseas. And lawfully, you cannot have a family member ship your medications overseas. It's illegal to mail other prescriptions, especially overseas. A pharmacy can mail them within U.S. An individual cannot mail prescription medications. So the VA will not forward me my medications down here to Nicaragua. As you'd heard before, I looked for a biosimilar here. So with the VA, even without the rheumatoid being service connectable, my biosimilar for the Humira, which is can't can't think of the name right now, the Hadlima. Those medications cost me $0 through the VA. If I wanted to get the biosimilar that's available here in Nicaragua, it was going to cost me $1,650 monthly out of pocket. And because it's not service connectable yet, the VA would not reimburse me for that. So it was the understanding that it was going to be far cheaper for me to have to fly back every 3 months to get a medicated order or to get a refrigerated order of medications to hand carry with me on a plane than it was to buy locally out of pocket. So the only real reasons I'm looking at my rheumatoid claim down the road is it would be nice to have the option to be reimbursed to buy local medication and not jump on a plane continually back to the States. And two, it's personal satisfaction for the government to acknowledge what they've done to you. So often the money is important. The award of the disability, acknowledging what you've endured, what you've said to people, the VA, for years, that you're correct. That personal validation and vindication means a lot. The housebound. I technically would not meet all criteria today. However, the appeal doesn't go into today. It goes to the date that I filed the appeal. And there is solid evidence that for nearly 2 years, I was a hermit. And that should have qualified for the housebound status. I would even be happy if they just acknowledged the 20 months for a housebound status and just acknowledge that I was correct instead of misreading their own rules and regulations and then regurgitating the same answers without looking at the evidence provided in front of them. So I would take that as a partial win. But these are the things still going. So I know this is cumbersome. I'm an hour into this understanding for all you. But ultimately, do not give up. If your claim is warranted, fight, fight, fight. Go find a knowledgeable service officer who will assist you. Talk to people. Everybody's going to have a good story. Everybody's going to have a horrible story. There's lots of stories. Find somebody that's willing to know how to do the job and file the claim on your behalf. I will advise you until and if the day comes that you need to be in front of the U.S. District Court of Appeals not to look at attorneys. The laws have changed. They can charge you a lot more money. A lot of people went with private attorneys on the class action lawsuits for Lejeune. There are significant issues when filing a civil case against the federal government. There is a term you want to research called total federal offset, where unfortunately it's give $100, take back $99. And often a good service officer means you don't have to pay an attorney 20 to 40% of your winnings that you fought years to get. Also, many of the private attorneys won't take your claim if you're already over a certain percentage because it's not worth their money. The simple fact that they won't take your claim because it's not worth a lot of money to them tells me they're not working in your best interest. They're working in their best interest. So I will give that shout out to Bergman & Moore. At the court level, at the federal level, they are absolute rock stars. They are at the top of their game. They kept me informed consistently. They were professional. And that's my snapshot for this. I hope you all well with that. I do want to hit you up. If you find the information useful, please hit the like, hit the subscribe, share this with friends, share this with families, share this with a veteran that you know. Could be a lot of difference. The simple fact that somebody takes an interest in the veteran's claim often is monumental to veterans when they feel that nobody's listening or nobody believes them or nobody will take an appreciation for the pain or turmoil they're going through. Listening. It means a lot. All right. Thank you very much. That's an hour plus rant. Hope you all well. I should be having the next video coming up in about a week's time. I have that crazy music instrument that I showcased in Florida. Should be arriving in about a week's time through Envios Fast Track, potentially handing off to Cargo Trans. Hopefully we get a direct delivery to the apartment this time. I will do a full after-action review on that one as well. That is the last pending order I have at the moment. And the rain's kicking back in. Thank God. All right. With that, I wish you all well. And until next time, adios.